Hands where I can see them right now. You are being detained.
Detained for what, specifically? State your reasonable, articulable suspicion.
Don't cite law at me. Produce your edification right now or you are going to jail.
You are escalating without legal cause. I am asking you to call your supervisor.
I said give me your hands now.
Officer Stevenson, your body cam is recording a federal civil rights violation in real time. I need you to understand that fully before you take one more step.
At exactly 6:12 a.m., under the pale fluorescent lights of a BP station on the north side of Chicago, a routine suspicious person check that should have lasted 2 minutes turned into the most expensive decision of one officer's career. The kind of station where the pumps run all night, where the security cameras cover every angle without opinion, and where the footage uploads automatically to a server that no one can reach or delete. That footage would go viral within 36 hours. Millions of views, thousands of people replaying it frame by frame like evidence in a trial, because that is exactly what it became. But what made it different from every other gas station confrontation caught on camera wasn't just the aggression or the dismissal or the handcuffs clicking shut against the side of a $90,000 SUV on a quiet weekend morning. It was who was standing at that pump. She was a 52-year-old black woman in a tailored suit, calm and composed, on her way to an early morning judicial conference before most of the city had finished its first cup of coffee. She had spent 2 decades on the federal bench. She had presided over the constitutional laws that governed every arrest, every stop, and every use of force in the entire Northern District of Illinois. Her signature appeared on federal warrants. Her rulings shaped how law enforcement operated across the region. Officer Marcus Stevenson did not know any of that when he pulled into the station with his spotlight already blazing and his voice already raised. He had made his decision before he got out of the car. And by the time he realized what he had done, it was already recorded from 6 different angles, including his own chest. Subscribe right now and drop a comment telling me where you're watching from. Because the moment Stevenson looked at Judge Zuri Washington's federal judicial ID and called it a clever forgery, is the moment this $5 million story was already over. Zuri Washington had learned early that the law was not a building or a title or a robe hanging on a hook behind a heavy door. It was a practice, something you did every single day, in every room you walked into, with every decision you made. She had been practicing it for 22 years, and she had not once taken a day of it for granted. She grew up in Bronzeville, on Chicago's South Side, in a house where the television news was treated like homework, and dinner table conversations were expected to have a point. Her father was a high school civics teacher who graded papers until midnight and believed, with the kind of faith that does not require evidence, that an informed citizen was the most powerful force in a democracy. Her mother was a social worker who spent 30 years watching the law fail the people it was supposed to protect, and who told Zuri that the only acceptable response to that failure was to get inside the system and fix it from where it actually broke. Zuri had done exactly that. She graduated from the University of Illinois with honors, earned her law degree from Northwestern, and spent her first 6 years as an assistant U.S. attorney in the Northern District, where she prosecuted public corruption cases with a precision that made her supervisors stop by her office to ask how she had found whatever she had just found. She was appointed to the federal bench at 41, the second youngest appointment in the district's history. In 2 decades on the bench, she had presided over more than 9,000 cases, written opinions that were cited in federal courts from New York to California, and built a reputation for being, as one Chicago Tribune profile had put it, the judge who reads every word of every filing and remembers all of them. She was known in the legal community for her stillness. Not the stillness of disengagement, the opposite. The stillness of a woman who was always processing more than she was showing, who listened completely before she responded, and who had learned that the most powerful move in almost any situation was to remain exactly calm while everything around her was not. She was 52 years old, and on Saturday mornings she made herself 1 cup of strong coffee, put on her best suit, and drove herself wherever she needed to be, because she had never once owned a car she didn't love driving, and she saw no reason to stop. This particular Saturday, she needed to be at a judicial conference on the west side by 8 o'clock. She left her house at 5:55, took the route she always took, and pulled into the BP station on North Kedzie at 6:10 to fill the tank. The station was quiet. The street was empty in the gray early morning light. She swiped her card and started the pump and was checking her phone when the spotlight hit her. Marcus Stevenson had been a police officer for 11 years and had spent most of them operating on the belief that instinct was more reliable than evidence. His instinct had told him many things over those 11 years. It had told him that certain cars in certain neighborhoods needed a closer look. That certain people at certain hours were probably up to something. That the officers who asked too many questions before acting were the ones who let things slip through. He was 36, built solid, with a way of moving through his shifts that other officers described as always on. He was never relaxed on patrol. He was never simply present. He was always scanning, always looking for the thing that confirmed what he already suspected was out there. His training officer in his first year had told him that good police work required patience and observation. Stevenson had taken the observation part and left the patience behind. He worked the 14th District, which covered a stretch of Chicago's northwest side that included both working-class blocks and newer, more expensive development along certain corridors. The tension between those two zones, between who had historically lived there and who was moving in, was something Stevenson had a theory about. His theory was not complicated. It came down to who he thought belonged where. He had made 22 traffic and pedestrian stops in the previous 9 months that his own supervisor had flagged internally as lacking sufficient documented basis. Those flags were in his file. They had never resulted in any formal review. His numbers were high, more stops, more citations, more arrests than most officers in his district. And in a precinct that measured performance in volume, high numbers created a kind of protective cushion that absorbed a great deal of what might otherwise have required attention. He also had a habit that 4 of his fellow officers knew about, and none of them had formally reported. He kept a personal tally on a notepad in his center console. Stops by vehicle type, by neighborhood, by what he described to himself as profile match. He had been keeping the tally for 3 years. He considered it data. On that Saturday morning at 6:09, he received a radio call about a suspicious person report near a BP station on North Kedzie. The description in the call was vague. A person in a dark vehicle, acting unusual. No specific behavior was described. No threat was indicated. Stevenson was 2 blocks away. He headed for the station with the spotlight already in his hand, the way he always did when a call felt, by his instinct, like something worth moving fast for. He pulled into the lot and swept the light across the pumps. He saw a black woman in a tailored suit standing next to a $90,000 SUV. His instinct fired. He was out of the car before the engine fully stopped. Zuri heard the vehicle before the light hit her. She heard the fast pull into the lot, the gravel scrape of tires moving with purpose, and she turned her head and saw the spotlight sweep across the pumps and land on her. She stood still. She kept one hand on the pump handle and placed the other flat on the side of her vehicle where it could be clearly seen. She had read enough case files and presided over enough stops to know exactly what the next 60 seconds could become if she moved wrong, even though she had done nothing and was doing nothing and had not been doing anything except fueling her car at 6 in the morning on a Saturday. Stevenson was out of his cruiser and across the lot in under 15 seconds. "Hands where I can see them," he said, his voice already set to maximum volume. "You are being detained." "Good morning," Zuri said. Her voice was the one she used in her courtroom, level, clear, built for rooms that needed to hear every word. "I have both hands visible. What is the basis for this detention?" "Suspicious person report. This vehicle matches a description." "What description specifically? What is the report number?" "Don't cite procedure at me," he said, moving closer. "Produce your identification right now." "I will produce my identification," Zuri said, "after you state the legal basis for this stop. That is not a delay. That is a lawful question." Under Terry v. Ohio, you are required to have reasonable articulable suspicion of a specific crime before detaining me. I am asking you to articulate it." Stevenson stared at her. She watched something move across his face. Not recognition, not reconsideration, but the specific irritation of a man who had not expected to be answered with case law from someone standing at a gas pump. "You are being detained," he said again. "Last warning. Identification." "Officer Stevenson," Zuri said, reading his badge. "I am Judge Zuri Washington, United States District Court, Northern District of Illinois. I have federal credentials in my jacket pocket. I am going to reach for them slowly." She held his gaze. "I am telling you my title so that you have the information you need to make a different decision than the one you appear to be moving toward." He did not make a different decision. "I've heard every story," he said. "Judge, lawyer, doctor, everyone's something when I pull up. Hands on the trunk." "I am not required to comply with an unlawful order," Zuri said. "Hands on the trunk, now." She placed her hands on the trunk. She was completely still. But her mind was already moving, building the record the way she had always built records, from the first moment and without pause, because she had spent 22 years learning that the details always end up mattering. She noted the time on the pump display, 6:12 a.m. She noted the angle of the lot camera above the station door. She noted the 360-degree security system active on her own vehicle. She noted everything. The BP station on North Kedzie had 6 cameras. The lot camera above the entrance door. A second camera angled at the pump island from the south. A third mounted on the car wash structure at the back of the property. And 3 interior cameras inside the station itself, 2 of which had sight lines through the front window to the pump where Zuri was standing. Zuri's vehicle added 4 more. Her SUV was equipped with a 360-degree high-definition security system that recorded continuously when the engine was running. All 4 exterior cameras were active. All 4 had clear audio capture through exterior microphones. Stevenson's Bodycam was running. That was 10 recording devices total, capturing the next 4 minutes from angles that would later be described by the federal prosecutor assigned to the case as essentially a complete documentary record. Stevenson ordered Zuri to keep her hands on the trunk and told her he was going to conduct a search of the vehicle. Zuri told him clearly and calmly that she did not consent to a search, that no warrant existed, and that he had still not provided a legal basis for the stop. She said each of these things in a composed, even voice, the way she would instruct a jury, because she understood that everything she said was going into a record that would eventually be heard by people who were not Marcus Stevenson. He reached into her jacket pocket and removed her credentials. The federal judicial identification card for the Northern District of Illinois was gold embossed, laminated, and bore her photograph, her full title, the federal court seal, and a verification number that connected directly to the 7th Circuit Administrative Office. It was one of the most clearly official documents the United States government issued to anyone. Stevenson looked at it for a long moment. Then he said, "This is a clever forgery. I've seen better." Zuri said, "The verification number on the lower right connects to the 7th Circuit Clerk's office. They answer calls 7 days a week for exactly this situation. I am asking you to call it." He put the card in his vest pocket. "Hands behind your back," he said. "Officer Stevenson," Zuri said, and her voice went to the register that cleared courtrooms. "I am narrating this for the record. I am a federal judge. I have presented valid federal credentials. I have not resisted, threatened, or obstructed. What you are doing right now is a deprivation of rights under color of law, which is a federal felony. I am asking you one final time to call your supervisor." He cuffed her against the side of the SUV. The pump display behind her read 6:14 a.m. The lot camera had a clean angle. The body cam had a clean angle. The vehicle cameras had 4 clean angles. A man who had pulled in to use the ATM on the far side of the lot had his phone up and steady and had been recording since the spotlights swept across the pumps. 10 recording devices, all running, all capturing the same thing. Stevenson had made a federal case out of nothing, on camera, from every direction, and he did not know it yet. The man at the ATM was named Gerald Park, a night shift nurse who had stopped for cash on his way home from a 12-hour shift. He had seen the spotlight, watched Stevenson cross the lot, and pulled out his phone before the first exchange of words. Because he had grown up in Chicago, and he knew what a fast spotlight and a faster exit from a cruiser sometimes meant. He recorded 4 minutes and 22 seconds of footage. His angle was slightly oblique but clear enough to read Stevenson's badge number and clear enough to show Zuri's hands. Always visible, always controlled, throughout the entire encounter. He posted the footage at 6:31 a.m., before Stevenson's cruiser had left the lot. By 7 a.m. it had 12,000 views. By 8 a.m., 60,000. By the time Zuri was being processed at the 14th District Precinct, the video had been picked up by 2 local news stations and was being shared across every platform fast enough that a producer at a national outlet had already called the BP station asking for their surveillance footage. Zuri's vehicle cameras had transmitted their recordings automatically to her cloud account at 6:18 a.m., the moment she had pressed a small button inside her left jacket cuff, a habit she had developed after presiding over 3 cases where vehicle footage had been tampered with during police impoundment. 4 high-definition recordings, including full audio of every word Stevenson had said, were sitting securely on a server that Stevenson could not reach before Stevenson had finished filling out his arrest report. Back at the precinct, the processing desk was staffed by Sergeant Diane Cho, a 12-year veteran who handled intake with the efficient calm of someone who had seen most things. She looked up when Stevenson came through the door with a woman in a tailored suit, and she performed the same rapid inventory that every desk sergeant in every previous story had performed. She knew that face, not from a personal meeting. From the legal education module that the precinct had completed 4 months earlier, a mandatory training on federal judicial authority in the district that had included photographs of every sitting judge in the Northern District because the training designer had considered it relevant for officers to know who they might encounter. Sergeant Cho had paid attention during that training. She stood up very slowly. She said, "Stevenson, stop walking." He stopped. "Do you know who this is?" she said. "Suspicious person, resisting," he said. "Fake federal ID, won't comply." Cho came around the desk. She looked at Zuri directly. "Ma'am," she said, "can you state your name and title for me?" "Zuri Washington," Zuri said. "United States District Judge, Northern District of Illinois. My credentials are in Officer Stevenson's vest pocket. The verification number on them connects to the 7th Circuit Administrative Office." She paused. "I have been asking someone to call that number since 6:12 this morning." Cho looked at Stevenson for one long, quiet moment. Then she reached for the phone. Sergeant Cho made 3 calls in the first 6 minutes. The first was to the 7th Circuit Administrative line, where the weekend duty administrator confirmed Zuri's identity, her title, and her current active status in under 90 seconds, and then asked in a voice that had gone very tight where Judge Washington currently was. Cho told her. The duty administrator said, "Do not process her. Do not fingerprint or photograph. Keep her comfortable and call the precinct commander immediately." The second call was to the precinct commander, a 26-year veteran named Deputy Superintendent Leonard Okafor, who was at home with his Saturday morning coffee when his phone rang. Cho told him in precise, flat language what had happened, who was involved, and what was currently recorded from at least 6 angles that she knew of. She told him the video was already online with over 100,000 views. The commander set down his coffee and said nothing for approximately 4 seconds. Then he said, "I'll be there in 20 minutes. Do not let Stevenson leave the building." The third call Cho made was to the department's legal counsel, who was also at home, who also went very quiet when told, and who asked one question before hanging up. "How many cameras?" "At least 10, Cho said. The counsel said something under his breath and hung up. Zuri was brought to a private office, not a holding room, not a processing area, and the cuffs were removed by Cho personally, with an apology that was brief and genuine. Zuri accepted it with a nod and asked for her credentials back. Cho retrieved them from Stevenson's vest. He had not spoken since Cho had told him to stop walking. He stood near the processing desk with the particular stillness of a man who was beginning to understand the full shape of what he had done, and was not yet able to speak around it. Commander Okafor arrived at 7:08 a.m. He went directly to the office where Zuri was waiting, introduced himself, and said, "Judge Washington, I want to offer my sincere apology for what happened this morning. I want you to know that this matter will be reviewed at the highest level of this department." Zuri looked at him with the expression she used when a party in her courtroom said something she was going to need more than words to verify. "Commander," she said, "I appreciate that. I will need a complete copy of all Bodycam footage, the original dispatch log for the suspicious person report, and Officer Stevenson's full stop history for the past 2 years. I would like those materials submitted to my office by 9 a.m. Monday." She paused. "I also want you to know that the DOJ Civil Rights Division will be receiving a call from me before noon today, not as a threat, as a notification, because this is not only about what happened to me." Okafor said he understood. Stevenson was placed on administrative leave at 7:22 a.m. He walked to his car in the precinct parking lot and sat inside it for a long time without starting the engine. The video had 300,000 views by the time he drove home. The DOJ Civil Rights Division received Zuri's call at 11:47 a.m. on Saturday. By Monday morning, a formal inquiry had been opened. By Wednesday, it had been upgraded to a full pattern and practice investigation. By the following Monday, federal investigators had submitted a comprehensive records request to the 14th District that covered 36 months of stop data, complaint records, training logs, and internal review documentation. The precinct's legal counsel, who had spent the weekend preparing for exactly this, delivered the requested materials in 14 boxes. The investigators went through every box. What they found inside those boxes was the kind of evidence that experienced federal attorneys describe as self-documenting. It did not require interpretation or inference. It simply required someone willing to read it all the way through, which previous supervisors had apparently chosen not to do. Stevenson had made 94 traffic and pedestrian stops over the previous 2 years. Of those 94 stops, 67 had been conducted in mixed-income and upscale corridors in the district. Of those 67, 51 had involved Black or Latino drivers in vehicles valued above $40,000. Of those 51 stops, 4 had produced citations. The other 47 had produced nothing. No violations, no crimes, no basis anyone could reconstruct from the reports Stevenson had filed, which tended to use the same 3 phrases in rotation: matches description, unusual behavior, and area known for vehicle theft. The area known for vehicle theft designation appeared 22 times. Federal investigators checked the district crime data. Vehicle theft in those specific locations during the period cited was below the city average. 22 of the individuals Stevenson had stopped agreed to speak with investigators. They came one at a time to a neutral location and told their stories with the careful detail of people who had been waiting, in some cases for years, to be asked. A pediatric surgeon stopped twice in 3 months. An architect questioned at a parking garage for 11 minutes while his colleagues watched. A principal pulled over on her way to a parent-teacher night and made to stand on the sidewalk while Stevenson ran her information 4 times. A retired firefighter, 61 years old, who had been stopped so many times in his own neighborhood that he had started taking a different route to avoid the 14th District corridor. Every single one of them was black. Every single one had been driving a vehicle that cost more than Stevenson made in a year. None of them had believed at the time that filing a complaint would accomplish anything. They were right then. They were no longer right now. The investigators compiled their findings into a preliminary report that was 408 pages long. The executive summary was 2 pages. The second paragraph of the executive summary used the phrase systematic racial targeting and did not walk it back. The department's legal counsel read the summary, set it down, and called the commander. He said 3 words: "Settle everything now." The federal trial of Marcus Stevenson opened on a Tuesday in June, in a courtroom in the Dirksen Federal Building in downtown Chicago, and it was full from the first hour of the first day. Stevenson was charged with 3 counts. deprivation of rights under color of law for the unlawful stop, detention, and use of force against Zuri at the gas station, filing a false official report because his written account described the stop as a response to a credible suspicious vehicle report when the original dispatch log showed the call had contained no vehicle description, no license plate, and no specific concerning behavior. And unlawful search because the search of Zuri's jacket and the removal of her property had occurred without consent, without warrant, and without any legal basis that Stevenson had been able to articulate at the time or at any point in the 14 months since. The prosecution's opening statement was 15 minutes long. The lead prosecutor then told the jury they were going to watch some footage, and she sat down and the footage played. It played for 11 minutes. It was assembled from 7 of the 10 recording sources: the lot camera, the pump island camera, 3 of Zuri's vehicle cameras, Stevenson's body cam, and Gerald Park's phone. The clips were edited in chronological order with timestamps displayed in the corner. No narration, no commentary. Just what happened, in sequence, from every angle, including the 45 seconds in which Stevenson held Zuri's federal judicial ID in his hand, turned it over, and called it a forgery. The courtroom was completely silent for the entire 11 minutes. When the footage ended, the prosecutor stood up and said, "The United States calls its first witness." Over 4 days, the prosecution called 9 witnesses. The Seventh Circuit duty administrator, who had confirmed Zuri's identity in 90 seconds on a Saturday morning. Gerald Park, who described what he had seen and why he had started recording. 3 of the 22 individuals from the pattern and practice investigation who had agreed to testify in person. The federal data analyst who had spent 3 months with the stop records and who explained in clear and simple language what the numbers showed when you read them all together. And then on the morning of the 5th day, the prosecution called Zuri Washington. She took the stand in a dark suit and answered every question with the precision of a woman who had spent 22 years listening to testimony and knew exactly what made it useful. She was factual, sequential, and complete. She described each moment of the stop in the order it occurred, citing each statute violated at the moment of the violation. When the defense attorney cross-examined her, she answered every question directly, corrected 2 factual misstatements without apology, and remained so absolutely composed throughout the entire 50-minute cross that one juror later told a reporter she had the impression of watching someone who was simply reporting what had happened, because that was exactly what she was doing. The jury deliberated for 13 hours across 2 days. Guilty on all 3 counts. Marcus Stevenson was sentenced to 4 years in federal prison on a Thursday morning, and the federal judge who handed down the sentence was not one of Zuri's colleagues, but a judge from the Southern District who had been assigned specifically to avoid any appearance of conflict. She sentenced him methodically and without drama, citing each count, the evidence supporting it, and the specific harm caused. She noted the pattern and practice findings and said in her closing remarks that the sentence was proportionate not only to what Stevenson had done at a gas pump at 6 in the morning, but to what the record showed he had been doing for years to people who had not had a 360-degree security system on their car or 22 years of federal bench experience in their head. Stevenson was remanded into custody immediately. His pension was forfeited under the federal conviction. His law enforcement certification was permanently revoked. The city of Chicago settled with Zuri Washington for $5 million 6 weeks after the verdict. The terms of the settlement, which Zuri had insisted be made public, included the full implementation of a reform package that she had spent 3 months designing with input from civil rights attorneys, community advocates, and every one of the 22 individuals who had spoken to federal investigators. The reform was called the Washington Accountability Standards, a designation the city had proposed and Zuri had accepted on one condition: that the standards apply to every law enforcement agency operating in the Northern District, not only the 14th Precinct. The standards did 4 things. They required every precinct in the district to implement a real-time stop data system that flagged any officer whose stops showed a racial disparity greater than 2 standard deviations from the district baseline, triggering an automatic review within 30 days. They created a federal judicial encounter protocol, a written procedure for any officer who stopped or approached a person who identified themselves as a sitting judge, requiring immediate supervisor notification and credential verification before any further action. They established an independent civilian review board for the Northern District with full access to stop records, complaint histories, and training documentation, and with the authority to refer cases for federal investigation. And they created a mandatory annual bias training program developed in partnership with the 7th Circuit itself, required for every sworn officer in the district, and reviewed and updated each year. The settlement funded all 4 programs for a minimum of 10 years, with the remainder directed to a legal aid fund for individuals who had experienced unlawful stops and could not afford representation. Zuri did not hold a press conference after the settlement. She issued a written statement that was 4 paragraphs long. The last paragraph said that the outcome was not about her, that she had the vocabulary and the credentials and the 10 recording devices that most people did not have, and that the only acceptable measure of what had happened was whether the next person stopped at a gas pump at 6 in the morning. Without a federal ID in their pocket and a 360-degree camera on their car, would have a better chance at justice than they would have had a year ago. That was the standard she had set. She intended to hold everyone to it. On the following Saturday morning, she made her coffee, put on her suit, and drove herself to the conference she had been trying to reach 11 months earlier, taking the same route, stopping at the same station. She swiped her card. She fueled the car. The lot was quiet, and the morning was gray and cool and completely ordinary. She drove the rest of the way without incident, arrived exactly on time, and walked into the conference room ready to work.